The first matter to come before the court this morning is Wildberry Homeowners Association versus Williams Schuffert. Each side will have 15 minutes to present oral argument this morning. The appellant may reserve up to 5 minutes for rebuttal. If you're the appellant and want to reserve time for rebuttal, if you let me know when you get started. I'm keeping the clock up here so I can keep you apprised of the passage of time. The court's read the briefs, we're ready to see when you are. And if you would utilize this podium up here, that way we get to see your face even better.
That's the first text.
Good morning, Your Honor, members of the panel. My name is Kenneth Resar. I'm here on behalf of the appellant, Mr. Schuffert, and I would like to bifurcate my time and reserve 5 minutes for rebuttal. This case is basically about an improper decision by the court to begin with because it completely relied on the wrong statute. It relied on a statute set forth in 1311 dealing with condominiums to say that my client had no right to raise a counterclaim or an affirmative defense that the association had failed to comply with its arguments. This is a homeowners association. It is not a condominium association. The court specifically based its decision on the statute dealing with condominium law, and that statute does not apply here. There is nothing in the statute, which is chapter 1312, that has an analogous provision that prevents a aggrieved homeowner from raising a defense in a foreclosure action. That's number one. We also have the issue of the reasonableness of the attorney's fees and how they went about charging those attorney's fees, and whether there is any evidence in the record whatsoever to support their claim for attorney's fees. The record in this matter contains basically the affidavit of William Schuffert, who is the defendant, the affidavit of Barry Barnett, who is the representative of the plaintiff, and Andrew Geronimo, the plaintiff's counsel. In both of the plaintiff's affidavits, they put no evidence in whatsoever with respect to the reasonableness of the attorney's fees. The only thing they put in the file, the only thing in the record, is a reference to their accounting that showed how much had been charged for attorney's fees to the association, and then how much they charged Mr. Schuffert. There's nothing in the record whatsoever to show how many hours they worked, how much they charged for the time, or whether or not the work that they did was reasonable considering what action was being taken here. The case law, and I believe in Ohio, is pretty clear that evidence has to be in the record. In the appellee's response brief, they refer to some domestic relations court cases that say, well, we don't have to hold a hearing. Well, that's based on a different statute anyhow. That's support statute under 310518, which allows the domestic relations court to treat things differently. And even in those cases, they're really dealing with the cases they cited, dealt not with whether or not there was evidence in the record to support the reasonableness, but whether or not a party was entitled to it based on the domestic relations law. Certainly not condominium law and not homeowners association law. As they asserted in their complaint, the plaintiffs in this matter, this is a breach of contract. It's a breach of a covenant. That's in the homeowners association. Also, under that, the homeowners association here provides specifically what the homeowners association has to do to obtain attorney's fees and when they are entitled to attorney's fees. That's set forth in the declaration. This declaration in this homeowners association was enforced in 2002. The statute that they're relying on for attorney's fees was not effective until 2010. The statute specifically says that to the extent that it is in conflict with any term or is inconsistent with any term that is set forth in a declaration that was previously in existence, the prior declaration controls. The declaration of the Wildberry Homeowners Association specifically provided that they had to provide certain notices and that they were only allowed to charge attorney's fees to a homeowner after a judgment had been obtained. That is set forth in in the declaration, and the word, basically the homeowners association may foreclose the lien against the property, and in the event a judgment is obtained, such judgment shall include costs of the action and reasonable attorney's fees. They charged Mr. Schuffert attorney's fees long before this action was ever started. The actual problem here started back in 2011 when they assessed Mr. Schuffert $437 worth of attorney's fees. He asked them why. That's in his affidavit. They refused to give him any documentation as to why they were assessing him $437 in attorney's fees. At that point in time, he had been current in all of his assessments, as evidenced by the documentation submitted by the Homeowners Association. He dealt with them for 6 months, attempting to get them to say, what's this for? Why do I have to pay $437? What did I do wrong? They refused to give him anything. Ultimately, he quit paying his assessments. I'm not saying it was correct, but that's what he did. They then continued to charge attorney's fees, or started to charge attorney's fees to him, and continued to refuse to give him any documentation or any information, and throughout the whole court proceeding, they have never once supplied any documentation to Mr. Schuffert, to his counsel, or to the court as the basis for their attorney's fees. The statute which allows for attorney's fees, and I don't believe it's controlling because I believe that the declaration actually controls, but even if the statute controls, which is 1311, I believe, 131211, I'm sorry, provides a series of notices that they have to give in the event they are going to provide an assessment or assess a homeowner.
Nate, you're using the word assessment, and explain to me at what point this became a lien. Not until the end, somewhere in the middle?
Somewhere in the middle. It became a lien prior to the commencing of the foreclosure action. They had filed a lien. And I think it was in about 2013, and the assessment of attorney's fees started where he was charged for attorney's fees, and they sent him bills for attorney's fees, occurred in 2011, 2012, and 2013. They continued to charge him attorney's fees long before they ever even filed the foreclosure action. That is not allowed. One, pursuant to the statute, he has a right to get information. They have an obligation to provide him with a notice of why they're assessing him those fees. He has a right to challenge those. None of that was ever done. So we have a series of problems here. One, they had charged him attorney's fees. They never gave him any documentation for those as to the basis of those attorney's fees.
Question. Was the Homeowners Association involved in any litigation that resulted in attorney fees being assessed or being incurred to the Homeowners Association?
No, just the foreclosure action. There was no
other litigation that Homeowners Association was involved in?
No, not with Schuffert.
Well, I don't mean with him, I mean just the association in general.
I don't know.
Some other litigation that might have incurred attorney fees that needed to be allocated out to all of the homeowners.
I am not aware of that.
Okay, I'm just curious.
Never came up. Not that I'm aware of. Even if it was an assessment, it would have had been assessment to all the unit owners equally.
One would assume, yeah.
And I don't believe there was any such assessment. That would have to have been voted on. There's no evidence put into the record with respect to that. We have a basic fundamental issue here of one of due process. Is he entitled to a hearing, whether before the board, the homeowners board, as to why they are charging him with attorney's fees? Is he required to information? Then when he gets to the court, can the court award attorney's fees, which they have done in this, without any evidence in the record with respect to the amount of those attorney's fees, the hours that were worked, the rate that was charged, or the reasonableness of those fees? And we're dealing with a situation here where and it is set forth in there, he attempted to settle this case. We raised those issues in the brief in the motion for summary judgment, or in our response to the motion for summary judgment, as to the issue of reasonableness of their fees. If a party comes in and is saying, I'm being charged for attorney's fees, and I will pay you what you are claiming, and I will pay you $5,000 today, and I will pay you the balance of the $10,000 and another $5,000 in 60 days. So you will be paid in full. And when the Homeowners Association says, no, we will not take that, we're going to continue with our lawsuit. We're going to file our brief in our motion for summary judgment and proceed through the process, knowing that they were going to take them at a minimum 4 months before they could ever get a foreclosure judgment and a sale. And they were going to be paid in full.
You're about 10 seconds into your rebuttal time. You can continue or preserve as you wish.
I will do that. Thank you.
Good morning, Your Honor. Good morning, panel. My name is Andy Geronimo, appearing for Appellee Wildberry Homeowners Association. May it please the court. I would ask that the trial court's decision be affirmed in this case. I believe the trial court properly granted motion for summary judgment to Wildberry. The fact is that Wildberry has a valid lien based on Mr. Schuffert's admitted refusal to pay regular assessments for over 2.5 years. He admits, he makes this argument about a small portion, this $437, that really precipitated this case, but that does not change the fact that he admits that he owes a large portion of the fees and has not paid those fees. I think that issue is dispositive of this case under the statute and under the declarations. I believe that was enough for the trial court to grant Wildberry's motion for summary judgment. Even if you accept appellant's key argument that part of the amount owed was improper, he took the absolute wrong way to go about contesting that. There are provisions under the statutes for where he can, and under the declarations for where he can request a hearing. There's no record, there's no evidence in the trial court's record that he ever did so. He can also, under the statute, bring up an action to discharge the lien. There's no evidence in the record that he ever did any of that.
Well, I noticed that the trial court's entry says that it's striking information regarding settlement attempts. I'm not sure from where it's being stricken and if that was done sua sponte or if that was done at...
No, that relates to this bad faith argument that appellant is making. Appellant saying that all of these settlement talks is evidence of Wildberry's bad faith. We filed a motion to strike upon seeing those arguments in the trial court in the brief in opposition to our motion for summary judgment. I believe the trial court properly struck those as inadmissible under the evidence rules, and I don't see that has been separately appealed. I don't believe that issue to be technically before you. I believe the trial court properly struck that. I think appellant's failure to bring that as a separate issue is essentially waived that issue.
Right, and then the reason for the question was just to be sure that we were talking, and you said there's no evidence in the record of, other ways to go about disputing this assessment, and then I have this language about the trial court striking. So that's not evidence that was stricken by the trial court based on your motion that you're saying is not in there, or it is.
I'm saying there are procedures under the statute, under 53-1211, if appellant believed that he was entitled to a hearing, he was required to give notice in writing in a timely manner within 10 days, requesting that hearing. I've seen no evidence in the trial court that he did so. These settlement discussions came well after Wildberry incurred fees to deal with appellant's conduct in the neighborhood, to file the lien, to file its foreclosure actions. To my knowledge, all of those settlement discussions came after Wildberry incurred all of these fees.
And then were additional attorney's fees in the final judgment of foreclosure that were not assessed as part of the lien? There were additional attorney's fees granted after that?
Yes,
So
yes.
two sets of...
Correct. Attorney's fees are accruing under the declarations. I think even if you buy appellant's key argument that part of the liened amount was improper, I believe his argument still fails. He believes he was entitled to a hearing for these fees. Appellant was not entitled to a hearing for this legal fee. Wildberry was dragged into the fray because of appellant's disturbing conduct in the neighborhood. This all started back in 2011. Appellant believed one of his neighbors was in violation of the declarations by running a business out of her home. Apparently she had a company car parked in the driveway. Appellant complained to Wildberry. Wildberry investigated, received a response from this neighbor, said she was not running a business out of her home, that the car was just her personal car with a business logo on it. She produced through a lawyer a lease for the property where the business was actually run out of. Wildberry was satisfied that this other neighbor was not violating the declarations. Appellant was not satisfied. In terms of other litigation, while Wildberry wasn't a party to any litigation, appellant's neighbor filed a civil stalking protection order against him.
And I'm gathering none of that's in this record.
It is in the record. The
It
civil
is.
stalking protection order, the docket was attached to, I believe, our reply to the brief in opposition. And it's, some of that is cited within the trial court's judgment and decree. So Wildberry was dragged into the fray when appellant started harassing and physically threatening his neighbor, taking photos of his neighbor. We had to then intervene to try and find some way to enforce the declarations and stop this disturbing conduct. We even had to evaluate whether or not this civil stalking protection order, whether there was anything available to the association to try and help his neighbor out, really. That was the source of the fees. And again, even if appellant contested that he was not liable for those fees, he chose the wrong remedy. He simply stopped paying his regular assessments out of spite for over 2.5 years. He didn't continue paying his regular assessments and say, I'm not going to pay you for this. He didn't institute an action saying that this is improper, even after, before Wildberry filed its lien, it sent him letters saying you are in default, you have past due amounts owed, please pay the amounts owed or we're going to file the lien. Appellant did not pay those amounts. He did not institute an action once the lien was filed to have that discharge, and he's liable for those fees. Appellant believes he was entitled to a hearing under the statute. This is not a typical enforcement assessment. This is not something that associations are used to dealing with, this civil stalking protection order issue. The typical enforcement assessment is you have an unapproved shed or something in your yard. You're entitled to a hearing to determine whether under the declarations it's approved or if it's not, and then whether the owner will remove it if it's not approved, or whether the owner will be assessed the costs of removal. This is not that kind of assessment. This is something that Wildberry already incurred these costs in order to review appellant's disturbing actions against this single mother, and there were fees that were necessarily incurred, and I think that appellant is liable for it under the statute and under the declarations. I mentioned that he failed to timely request a hearing. Failure to timely request a hearing under the statute waives the hearing forever. Again, I mentioned he failed to bring an action to discharge this lien under 53-1212B. That would be the proper remedy once a lien is filed to say, I'm not liable for all or part of this lien. It wasn't until he got to the trial court that he started putting forth alleged defenses to this liability. And again, the defenses only apply to a very small portion of the lien. The large majority of the lien, appellant's counsel even admitted in oral argument that he refused to pay. On that basis, I believe the trial court's grant of motion for summary judgment was proper. I also believe that the trial court did not abuse its discretion in awarding Wildberry's attorney's fees. If you review appellant's own cases regarding attorney's fees, this is Unique and the Supreme Court case Bittner, a trial court's award of attorney's fees shall not be disturbed except for abuse of discretion. I think the trial court in its discretion properly awarded attorney's fees. The trial court's in the best position to make that evaluation. They see these cases all the time. They're familiar with the conduct of the parties, and I don't believe the trial court abused its discretion in doing so. Also, 53-1211 that authorizes the attorney's fees has no requirement for any evidence that is required to be submitted to support the request for the attorney's fees. It simply says that any assessment or charge levied in accordance with this chapter, as well as any related interest, administrative late fees, enforcement assessments, collection costs, attorney's fees, shall be a lien against the lot. There's no requirement in any of the statutes that they be reasonable, that associations provide hourly rates or amount of time worked. It's really within the trial court's discretion to determine whether or not that's reasonable. The parties each cited to this Nottingdale case, a Supreme Court case that was decided well before Section 5312 was enacted. It's factually very similar to this one, where an owner believed that the association was not meeting its obligations under the declaration, and then out of stubbornness refused to pay for a number of years. Again, that reasonableness standard comes in through Nottingdale. Nottingdale has been superseded by Section 5312, but even Nottingdale's reasoning gives this court, I believe, good reason to uphold the trial court's award of attorney's fees. In the absence of an award of attorney's fees, these associations incurred all these costs. It creates an undue burden on the remaining owners when other owners aren't paying their fees. Again, appellant refused to pay his regular dues for years, for over 2.5 years. If you look at Nottingdale, and this goes to the reasonableness of the fees, if you read the footnotes in Nottingdale, Nottingdale reinstated an attorney's fees award of over $12,000 to collect $2,500 in assessments. The Supreme Court found that to be reasonable. After full consideration of the circumstances in the case, I believe the attorney's fees at the time the trial court granted its judgment were less than the maintenance and late fees that the appellant owed. I believe the trial court, just seeing the low amount of fees, could find them reasonable without requiring additional evidence. And it makes sense that an association would be awarded its fees, because otherwise it becomes cost prohibitive to enforce the declarations against owners who are not paying. Appellant takes issue with the trial court's citing to the condominium statute, chapter 5311, in its judgment and decree. I don't believe the trial court was relying on that, but it was more of a persuasive authority citation. This is as to appellant's affirmative defenses and whether he's entitled to those affirmative defenses.
Well, it does seem like he's relying on it when he says, as per 531118B1, it is not a defense set off counterclaim or cross-claim. That doesn't seem like he's just, analogizing.
And I think even if that were the case, I don't think it's error. I think it would be harmless error, because again, it is not a valid defense to stop paying your association dues for over 2.5 years because you disagreed with a $437 charge on your statement. I believe that was the reasoning of the trial court, that at the time you get to this point where the association has been forced to file a lien, forced to file a complaint, all the briefing through the trial court, that defense as to a minuscule portion of this lien is essentially ineffective. He should have availed himself of the remedies available to him under 531211, 531212, to bring an action to discharge the lien, to request a formal hearing before the board.
Now, you said in your brief that the statutes were relatively indistinguishable.
Well, and I see this in some of the case law where they cite, homeowners associations will cite to the condominium statute and vice versa. There are lots of consistencies, there are some inconsistencies, but I don't think that the fact that that provision isn't contained within the homeowners association statute really matters in this case. And again, I believe that the trial court properly struck some of appellant's arguments regarding settlement discussions. I believe those arguments that he made here today are improper. I believe that should have been separately appealed if he was appealing the striking of that. As to the appellant's argument about the statute controlling over the declarations, we made this argument in our brief. I don't believe the statute and the declarations are necessarily in conflict. I believe the statute supplements the declaration and provides additional rights. There's nothing in these declarations that say these are the only types of assessments that the association may charge. And if that were the case, I think that would constitute a conflict. That would constitute a situation where the the statute is invalidating a portion of the declarations. There is no such language. And I don't believe those arguments to be persuasive as to the conflict. Again, this mess could have all been avoided if appellant would have just simply continued paying his regular assessments. We would likely not be standing here today if he continued doing that and took the proper methods to dispute this charge. I believe the trial court's decision granting Wildberry's motion for summary judgment was proper. I believe it did not abuse its discretion in awarding Wildberry's attorney's fees, and I would ask you to affirm the trial court's ruling in full. Thank you.
Counsel, you have just under 5 minutes.
Thank you. Appellee's counsel statement that the record contains information with respect to numerous items with respect to civil stalking protection orders and things like that. I've been on this case since the beginning. Today was the first time I heard a lot of that information. Never heard it before, not in the record. The only evidence in this record are 3 affidavits. And if you look at those 3 affidavits, there's not a one of them that mentions a civil stalking protection order. There's not a one of them that mentions any problems that they had to investigate to what he was doing with a neighbor, you know, or what may have been doing.
But that's in the summary judgment ruling about the civil protection stalking order.
It may be in the summary, but it's not in, it's not.
But it had, I'm sorry for interrupting, but doesn't that mean it had to get in the record some way?
Unless the court was wrong.
Well,
Unless the trial court made an improper decision based on evidence that was not in the record. I mean, it's not in the record. I mean, it was an attachment to their brief. You know, just the court's docket on that. But there's no evidence as to what actually the basis for that civil stalking protection order. You know, what happened at the hearing on that, you know, why they got it, if they got it, whether it was overturned. Okay. It's not in the record. The trial court, therefore, could not rely upon it. If the trial court relied upon it, the trial court was in error. If they relied upon it in granting the motion for summary judgment. You know, he's saying there that there was no requirement for a hearing, and we should have responded within 10 days. I believe the statute, which is 13-1211D, specifically says that to request a hearing, the owner shall deliver a written notice to the board not later than the 10th day after receiving the notice this division requires. So he has a 10-day time period that he has to respond, but only if he was given a notice that is required by section 13-1211C. The evidence before the court shows that that notice was never given. There's nothing in it. The affidavits that they put in, there was no notice given. My client's affidavit states that he never got a notice from them. They never provided him with any information.
Why are you using 13-1211 and not 53-12?
I'm sorry, Your Honor. It is 53-12. It is, I'm sorry.
Thank you, I'm looking at the
For any reference, if I said
transactions.
13, I'm sorry, it's 53.
Thank you, I'm sorry.
I should have known that. My page was turned over and I
Okay.
read the wrong numbers.
Because I'm looking at the statutes when you're saying it and going, wait a minute.
I'm sorry,
So
it
it's
is 53-12, Your Honor. I apologize for that.
Thank you.
He did not, there is no issue here that my client did not pay the assessments. We've never denied that he didn't pay those assessments. He submitted or attempted to submit a defense to that in that the Homeowners Association failed to enforce the other provisions of the declaration. Those other provisions of the declarations included, but weren't limited to the fact that they were not allowed to have businesses operating out of any residence or property located there. The basic law with respect to declarations, if you do not enforce your declaration on issues, you can't come back and just say, well, we're going to enforce this section of the declaration, but not this section. Once you stop enforcing your declaration, it can no longer be enforced. That was the crux of the argument that he wanted to present as a defense. Not that if you're not going to enforce these provisions, which are part of my contract with the Homeowners Association, that's what I signed up for. This was the association I was supposed to have. This is what you were supposed to do. You didn't do that, so if you don't do that, I don't have to pay over there. I don't have to pay my assessment. Would he win that at trial? I'm not sure. Does he have a right to present that as a counterclaim or as an affirmative defense? Yes, because in this instance, the statute that the court relied upon, the trial court, deals only with condominiums. That's 53.
Well, let me ask you, let's say that we buy your argument and it is that the trial court used the wrong law, and we remand it for the trial court to not consider the condominium law and just consider homeowners association law and case law on that. Then if your client loses, there's going to be even more attorney fees perhaps attached. So this could go on
Perhaps.
to a lot of money.
Oh, that could, and there could be more attorney's fees if he loses, right? And he could possibly win, because we don't have the facts on that. And that's the whole reason that the whole concept of the motion for summary judgment is you have to view the evidence in a light most favorable to the non-moving party. Mr. Schuffert was the non-moving party.
But we also, it's not me, but just like when defense attorneys stand in front of us sometimes and they say, remand us for new sentencing, and we're like, do you realize that you might get a higher sentence?
He might, and the issue though on that's one part. And, ultimately, if it goes back to the trial court, is there a likelihood that he's going to be found guilty of not paying his assessments and get a judgment for the assessments? That's a possibility, yes.
And counsel, I've allowed for extra time for you to answer Judge Carr's questions that you have utilized all of your time today.
Thank you, Your Honor.
Thank you. Thank you both
Thank you.
for your presentations today. The court will take the matter under advisement. We will issue a written opinion, which will be mailed to all sides as well as posted on the Supreme Court website.
Thank you, Your Honor.
Thank you.